prevent Judge Garland from making the same commitment, except if he wanted to have the flexibility to fire him, Mr. Durham, for something other than good cause. And yet repeatedly, over and over and over again, he wouldn't answer that question. He also refused to answer the question whether the Department of Justice will continue prosecuting people who cross the border illegally. Never mind that the Constitution obliges the President and all of the executive branch to take care that the laws be faithfully executed. Judge Garland wouldn't tell this committee that he would faithfully execute the laws. He refused to answer whether the repeated violent assaults on the federal courthouse in Portland, including multiple violent attacks on federal law enforcement officers, constituted terrorism. Indeed, to the extent he proffered an answer, he suggested that it did not because those attacks occurred at night, something that I am confident is a novel definition of terrorism, since I am not aware of any legal definition in statute or otherwise that defines terrorism as activity that only occurs when the sun is in the sky rather than at nighttime. He refused to answer to this committee whether or not the Department of Justice would urge that the Heller decision be overturned. The Heller decision, of course, is the landmark decision upholding the Second Amendment right to keep and bear arms. He refused to answer that question. He refused to answer whether he would reinstate Operation Choke Point, which abused federal regulatory authority to target politically disfavored individuals and companies. Subsequent to his hearing, I and many other senators submitted a series of questions for the record for Judge Garland. I didn't think it was possible for answers to be less forthcoming in writing than they were in person, and yet the answers to the QFRs are indeed less forthcoming. In response to a whole series of questions about the Durham investigation, his response was, as I testified at the hearing, I do not know anything about the Durham investigation except what I've read in the press. His response, when asked about the meeting on January 5th, 2017 in the Oval Office, where President Obama and Vice President Biden directed the Department of Justice and the FBI to target the incoming Trump administration and to target the incoming National Security Advisor, Michael Flynn, a meeting that is discussed at length in the Horowitz report, the executive summary, which Judge Garland said he has read. His response was, I do not know the facts of the situation you described. As I stated at the hearing, as a nominee, I should not comment about Justice Department officials' prior decisions or hypothetical situations. Mr. Chairman, I want you to pause to think about the two things he says he won't comment about. Anything a prior Department of Justice has done, he won't comment on that, and he won't comment on hypothetical situations. I'm not sure what remains if you won't comment about actual situations or hypothetical situations. What remains is essentially a null set. He refused to tell this committee whether he would reinstate the politicized decision-making of the Eric Holder and Loretta Lynch Departments of Justice, and he refused to entertain any hypotheticals whatsoever. When asked about Operation Choke Point, he said he wasn't familiar with it. Questions for the record asked, now that he's had an opportunity to familiarize himself with it, what are his views? His answers were, since the confirmation hearing, I have not studied these issues any further and have no additional comments. On the question of the Second Amendment and whether the Department of Justice would seek to overturn the Heller decision and effectively erase the Second Amendment from the Bill of Rights, what little commentary Judge Garland would provide in his written answers only raises cause for concern. He said in particular, I believe as a general matter that we should be very careful that people who are entitled to guns get the background check that allows them to have them, and that for those who are not entitled and who are concerned, who we are concerned about because they are threats, because they are felons, or for whatever reason are barred by the law, that there is an opportunity to determine that they are not permitted to have a gun. He makes no commitment to protect the Second Amendment. On the question of whether the Department of Justice would enforce immigration laws and in particular continue to prosecute those across the border illegally, here's Judge Garland's answer. As I said to Senator Hawley, I just haven't thought about that question. The President has made clear that we're a country of borders and with concern about national security. I don't know of a proposal to decriminalize, but still make it unlawful to enter. Since the hearing, I've not had time to think further about the question. So since the hearing, Judge Garland has not had time to think further about enforcing our immigration laws. This pattern is reminiscent of Sergeant Schultz out of Hogan's Heroes. What Judge Garland has told this committee is, I see nothing, I hear nothing, I know nothing. At times, when convenient, his answers to the QFRs resort to the judicial canons of ethics to say, as a sitting judge, he is prohibited from commenting on any particular issue. But I would note at the hearing, he was quite willing to comment about prosecutorial priorities when asked by Democratic senators to make commitments in that regard. Not only did he refuse to answer questions at the hearing, not only did he refuse to answer questions for the record, but Judge Garland is also one of the few Biden cabinet nominees refusing to take in-person meetings with senators, categorically refusing to take them. Multiple other Biden nominees are taking them. And so I would note to my colleagues on this committee, both sides of the aisle expressed considerable frustration with the Department of Justice that resist efforts of the Senate to engage in oversight. Judge Garland's conduct before this committee and his confirmation gives no reason for comfort in that regard. If he's not willing to answer questions now, before he's confirmed, the likelihood of his being willing to answer questions after he was confirmed is only smaller. On the response to the questions for the record, it is difficult for a lawyer to draft answers to this committee that are more of a jump in the lake to the Judiciary Committee than these answers are. They reflect a view that saying, I don't know, on any policy issue is acceptable to be confirmed as Attorney General. I very much hope that my initial assessment of Judge Garland proves right. From the vote on this committee, it appears likely that his nomination will move forward and that he will be confirmed. But for the Republican colleagues who have expressed concerns about another Holder or another Lynch Department of Justice, I would note that both Eric Holder and Loretta Lynch were much more forthcoming before this committee than Judge Garland. He has not even met the standard, the Holder or Lynch standard. And for this committee, the precedent this committee is setting is that a nominee for Attorney General can sit before this committee and essentially refuse to answer all questions. Say, I don't know, I can't tell you, I don't know. And whichever party is in the majority will vote to confirm that nominee nonetheless. That's a precedent I predict will come back to haunt this committee. And I hope that the votes to confirm him will not prove a mistake.
Thank you, Senator. For the record, Republican members of the committee submitted